Good morning, everyone. Welcome to the Utah Court of Appeals. I'm Judge Ryan Tenney. I am pleased to be joined by Judges Mortensen and Orm for today's cases. We have two cases set for decision today. This is the second of them, in re MS. If counsel could go ahead and enter your appearances, we'll start there.
Hannah Levitt-Howell and Emily Adams for the appellant, Your Honors.
Welcome.
Martha Pierce, Attorney Gardner, by the minor child.
Welcome. Mr. Peterson, I can see you, but I can't hear you.
Excuse me, Your Honor. Sorry, John Peterson, Assistant Attorney General for the state of Utah.
Great. Thank you, Mr. Peterson. As you all know, we outfitted our courtroom a few months ago with various technological apparatus. For moments like this, Mr. Peterson will be appearing remotely, and counsel are here. Hopefully everything will go well. Fingers crossed.
It is our inaugural attempt, right?
Is this our first? This is the first that I've... Okay.
Yeah, this is it.
This is the first of the hybrid hearings. As you're all veterans of our court, 15 minutes per side per argument. Clock will work backwards. It looks like you've reserved 3 minutes. Do I have that right?
Yes, Your Honor.
Okay. Any questions from any of the attorneys or judges before we begin? If not, we'll proceed.
Your Honors, this is a case that never should have happened. A nursing child was taken from his parents in the middle of the night without adequate justification. At the shelter hearing, the juvenile court denied parents their statutory right to a secondary medical opinion. And then later, to compound these errors, the juvenile court adjudicated that the child was neglected and ignored the statutory definitions, specific carve-outs for a secondary medical opinion or reasonable and informed medical decisions. And while thankfully the child is returned to the parents now and thriving, the harms of the juvenile court's errors continue to affect them in the form of that neglect adjudication. To that effect, parents raised two arguments before this court. First, that the juvenile court erred as a matter of law by awarding custody to DCFS at the shelter hearing. And second, that the juvenile court improperly adjudicated the child.
Can I start you with a question on the shelter hearing issue?
Yeah.
The argument, at least the initial part of all this, has to do with mootness. And you've asserted in your brief that under the Widdowson exception to the mootness doctrine, we can go ahead and reach it. The thing that struck me about the Widdowson factors was the second factor, the likely to reoccur. Is it reoccur? Recur? The likely to recur factor. And as I took your argument on pages 26 and 27 of the brief, I mean, your assertion is sort of just the following, that the juvenile court made a legal error here, and therefore it's likely to recur. I didn't see much by way of demonstration that this particular error is likely to recur. Can you help me with that? Like, how would we get there?
Yeah, Your Honors, the point here is that parents asked for the secondary medical opinion. They said, we have an appointment, would like time to take child to this appointment, and the court just said no. And without further direction from this court, there's nothing stopping the juvenile court from doing that in the future.
Let's assume that I agree with you that the juvenile court erred in that respect. How do we get through that second factor, though? What is it that shows me that this particular error is likely to happen again?
And maybe coming at it from a slightly different way. I've been doing this for 36 years now. I don't remember this having ever come up before. Now, we don't want to decide matters based on my personal testimonial, but it strikes me, in aid of Judge Tenney's point, that on the surface of things, this isn't just happening all the darn time.
Your Honors, that's correct. But it is likely that it does happen again if these medical neglect issues happen in the future. I mean, I don't see a lot of other statutory evidence besides the fact that this is a right that parents are guaranteed, and in this case, that right was ignored. So it is likely to reoccur in that parents will continue to be caught up into the system in this way, and perhaps that's not very often.
But if it turns out that this is just a one-off decision from a judge who kind of was going rogue, then we don't satisfy that exception, and then we leave it alone under mootness, don't we?
Your Honor, I think that the public policy, I mean, there is some likelihood that this is going to reoccur because it will continue. I mean, there is always the possibility that the court ignores that in the future, and the strength of the public policy and the likelihood of evading review if it was to reoccur should outweigh that one factor. That I think there's enough evidence that it's possible for it to reoccur, that there is some likelihood that it reoccurs, that second factor perhaps should give way to the strength of the first two factors, or excuse me, the first factor and the third factor.
Right.
Now what you're attacking specifically, though, is the court not giving them custody of the child at the shelter hearing, right?
It's two things, Your Honor. First, yes, that under 403, parents have a right to a secondary medical opinion.
Sure.
They also have a right to maintaining custody of the child while they get that secondary medical opinion. Unless there's those two exceptions. They have a right to maintain custody unless there's an imminent threat of immediate harm or deteriorating condition, and then they lose the right to the secondary opinion in general if there's an immediate threat of death or serious bodily injury, I think.
And you think this record wouldn't support a finding of a deteriorating condition?
It's possible, Your Honor, that you could find that there was a deteriorating condition, but under that fact pattern, parents still had a right to a reasonable amount of time to get that secondary opinion before custody was actually decided at the shelter hearing. And so even if parents...
And that's a good point, but did they ask the court to do that? Did they ask, and just so you know, last night I read the transcript,
Great.
so I'm right with you. Did they ask the court to have the foster parent take the baby down to this doctor in St. George and to delay the custody determination until that had happened?
Your Honor, they did not make that explicit of a request, but they did say, please give us time to take the baby to this appointment that we already have. And
I agree with you that it shows that. Can I ask you a couple of other questions that kind of build on each other? The judge said a couple of things. One is he said to the parties, I'm allowed to rely on hearsay in a shelter hearing. And I didn't see anything in your brief taking issue with an altered evidentiary standard at a shelter hearing.
that's correct, Your Honor.
Okay. Then the next thing is the court said that it was concerned with, and it posited it a number of ways in the different briefs. They've identified the actual medical term for it, but the court referred to it as liver damage, that the court was perceiving and made a factual finding that there was some sort of potential for liver damage, or that there had already been liver damage, and that seemed to be the hook that he was putting that on. And I maybe I missed it. Have you attacked that factual finding?
Your Honor, we did attack some of the factual findings, I believe on page 40 of the brief, but that may be me misremembering things. When the court held that the child was in serious medical danger, that was incorrect based on a number of things. First of all, I'm not a doctor, but the record seems to indicate to me that the liver damage could stem from the bilirubin count with the jaundice, and the dehydration could have led to seizures. So there were those two separate things, and the record indicates that the bilirubin count was indeed decreasing from as the parents did apply the blue lights and filled that prescription. Additionally, there's some.
But there was this condition that the infant's body was consuming platelets at a rate exceeding the amount that it was producing them, and that this was a concerning condition. Is that synonymous with the bilirubin issue? I didn't see that connection so clear in the transcript.
Yeah, that's fair, Your Honor. From what I understood, the platelet issue was perhaps just damaged blood that needed to be rerun. That the damaged platelets was there wasn't evidence that was actually a condition of the baby himself. And I think what highlights the baby's condition here is Dr. Stroschein's testimony at the trial. Dr. Stroschein made a number of different comments throughout the trial.
Now, and see, I appreciate that, but to me that's a separate issue. I don't think we can inform the decision that the court made at the shelter hearing with what we heard at trial, can we?
No, Your Honor.
Okay.
But what is also instructive about the shelter hearing issue is that it wasn't just an issue of whether the child had some health condition, right? I mean, it was an immediate risk, and also the juvenile court needed, in order for the juvenile court to properly adjudicate the child as neglected, the court had a responsibility to ensure that the statutory definition was met. And for the statutory definition to be met, those two specific carve-outs had to be untrue, if that makes sense. So the parent's decision needed to be both unreasonable and uninformed. Their decision to increase breastfeeding to every 2 hours when they were told that there was some risk of dehydration, or the state needed to prove by clear and convincing evidence that the parents were not in fact seeking a second medical opinion when they chose to not return to pediatrician and instead find another doctor. So unless
Well, can I, there's a little space in there. And I think, if I misrepresent the facts, totally correct me, but my understanding is they're at the shelter hearing, they're saying what we know about what's happened in the short time that the child's been alive, and then they're saying, we have the second opinion, we've got an appointment that is going to occur, and it's the soonest appointment we could get, but it's not tomorrow morning, right? And
I believe it was the
it
next
tomorrow
morning, Your Honor.
Okay. But if the trial court thinks that it's deteriorating right now as we sit there, does it necessarily have to not take any action and give them that time? Do you understand my question?
I understand your question, Your Honor. If the juvenile court believed that there was an immediate risk of death or serious bodily injury, that's the only point at which the juvenile court could say, parents, we're foregoing your right to a secondary medical opinion. The imminent risk is not enough of that.
Isn't it, and try to keep the shelter hearing separate from the final adjudication of neglect.
Yeah.
Isn't it, for custody purposes at the shelter hearing, isn't all that's required is a, quote, deteriorating condition?
So, Your Honor, just to make, I may be misunderstanding your question, and I
Yeah.
apologize if that's the case, but it seems to me, reading the plain language of the statute, that there are two factors at play. That first, the parents have this right, whether they maintain custody of the child during the secondary medical opinion or not. They have a right to time to
Yeah, but I'm
have that
not
done.
focusing on the time or the second opinion. I'm focusing on custody
Right.
determination at the shelter hearing.
So-
If the court finds that there's a deteriorating condition, setting aside when and how a second opinion is going to be obtained, isn't that sufficient to deny custody to the parents if the court finds a deteriorating condition? Do you understand that question?
I do understand that question, Your Honor. It is, I think, instructive that the legislature indicates it's only an immediate risk, an imminent risk of death or deteriorating condition, which seems different than just any deteriorating condition.
So you're saying that the word imminent also is defining the deteriorating condition?
Yes, Your Honor.
Although I'm having trouble, that's an active phrase, deteriorating. It's a condition that is presently deteriorating, so I don't know how that would not ever be imminent, but I'll have to ponder on that. Do you see what I'm saying?
It's a fair point. Yes, the
Yeah.
gerund does make it seem like it's an active.
Right.
Correct. So on that point, Your Honor, even if it was an active deteriorating condition, that would be against the clear weight of the evidence in this case that the court heard. The court's specific finding, regardless of what happened at trial, was that child gained weight after mother increased feedings. Immediately after child was taken from parents and weighed at the hospital with DCFS before the foster parents brought child back to be examined by Dr. Stroshine later that day, child had gained weight. And there was some indication that perhaps it was because of a wet diaper that the state and the guardian ad litem brought up in their briefing. However, the court's actual finding was that child had in fact gained weight, which would indicate that child did not have an actively deteriorating condition, but in fact was responding quite well to mother's actions and to what parents had reasonably and informed decision.
Your time has expired, but I had two more things that I wanted to make sure I asked you before you sat down, and since I'm chairing, I'm going to take the prerogative. Question number one, on the neglect, moving forward to the neglect issue, the neglect adjudication issue.
Yes.
There's this question of mootness, which, as I understand it, the mootness for the shelter hearing and the mootness for the neglect don't necessarily go hand in hand. On the mootness for the neglect issue, the Guardian ad litem on page 15 of its brief has given us several cases in which, according to the Guardian ad litem, the cases say that collateral consequences are not enough to get past mootness. Can you respond to that assertion? Do those cases say that? How do you get past mootness despite those cases?
Your Honor, those cases all seem to be responding to a different factual scenario, either some sort of active abuse or a parent is having their rights officially terminated. They're all significantly more, they're all just factually different scenarios that don't apply to this. And I mean, to move on into that mootness scenario, and stop me if this is not where you want to go, but.
Well, that was my specific question. We were past time, but go ahead and give us your short pitch on that. Yeah.
I mean, Your Honors, it seems to me, reading the Guardian ad litem's briefing and the supplemental briefing, that they're making some sort of argument that the jurisdictional impact of the adjudication is what can make it moot or not moot. And so, based on In re GB, where the jurisdictional impact of the first determination was negligible, because there was also the second determination that the whole issue is moot. And so the Guardian ad litem is arguing in this case that because there is no jurisdictional impact where this case is closed, that you should also consider the neglect adjudication moot. However, as the state pointed out and as we pointed out, there is an impact to the neglect adjudication.
That leads to the second question I wanted to ask, which was about In re GB. I have some familiarity with that case. You brought it up in the reply brief, and your first pitch on it was that it was materially distinguishable. And then the Guardian ad litem and the state have come back and they've said not only is it distinguishable, but it's irrelevant, is the term they used. So if we have a situation in which all of the parties at least agree that it's distinguishable, if not, it's irrelevant, do we need to engage with your next request, which is that we should overturn it?
No, Your Honor.
Okay. That's my question. Are there any other questions before we let her off the hook?
Nope.
Okay,
Thank you.
You'll have your full rebuttal time.
May it please the court, Martha Pierce, attorney guardian ad litem for the minor child. I want to direct this court to the doctor's notes from 326 that establish two things. One, that the parents already have had at 326 a pattern of not following through, and two, that the child had a deteriorating condition.
There was more to that than just the weight loss, right?
Because it's not just weight loss, it's also the electrolyte level. That was the crucial part, because people who watch football know you play in the sun, electrolytes, bad things can happen. So it's not just let's weigh the child and then we're fine. So the 326 meeting with the doctor, the doctor found several things where the parents were not following through. They were not waking him up to feed as they were instructed. They never got a repeat bilirubin. They didn't follow up with a weight check. So he's concerned that they're not complying with that. And then this doctor is committed to breastfeeding because he's asking the mother to pump and to measure her output. If he wanted her to abandon breastfeeding, there's no reason to do that. And significantly, the Dr. Wallstrom letter concurred on every important fact of the Merkley report on 326, that this was concerning, that you had to do repeat labs, that you had to do a volume check on the breast milk, and that it had to be monitored and do weight checks. So it fell lockstep into that. So you do have an establishment of deteriorating condition. Now, regarding invoking the right to a second medical opinion, you have, the case law is clear. You have to bring it to the consciousness of the judge, because this.
Can I pause you on that? I mean, one of the pieces of that argument, you've invoked Rule 33, and they've come back in their response and they've said Rule 33 on its plain language refers to an action by the court. Why are they wrong about that?
Rule 33 refers to what?
An action by the court. I understood their response to your Rule 33 argument to be that.
An appointed evaluator.
And pardon?
An appointed evaluator.
Okay. Well-
Rule 33, right? That's the language it uses.
Right. But I'm now talking about preserving this claim for appeal. And to preserve a claim for appeal, you have to bring it to the attention of the trial court so that you get a ruling. And to say, by the way, I have a well child check, says nothing about, I want this child checked for the issue of failure to thrive, for electrolytes, for that sort of thing. It's not brought to the consciousness of the judge.
Weren't they pretty express, though? I'm sorry.
No, I was just going to say, nothing quite as express as we want to assert our right to a second opinion in accordance with provision thus and so.
Right.
But they did use the phrase second opinion, right?
In the shelter hearing, they just said, we have a well child check coming up. They didn't say second opinion at the shelter hearing. So,
But doesn't, correct me if I'm wrong on this, but I thought she had said at the shelter hearing that they had an appointment, I think was the word.
they did say, we have a well child check appointment. They did.
Why is that not enough to bring it to the attention of the judge for preservation purposes? If they're saying to the juvenile court judge, we have an appointment with somebody else, and there is this statutory provision that hinges in part on a second opinion, why is that not it?
Well, they don't invoke the statute, and a well child check
Is that required for preservation, to invoke a statute specifically?
well, the law is pretty clear that you have to bring it to the consciousness of the court. You have to provide appropriate evidence and statutes. You have to provide that. And this,
Do you? That was a matter of preservation. I mean, preservation can sometimes get a little bit fuzzy as a concept. I'm not aware of a case. I haven't done a deep dive on this in a while, but I'm not aware of a case that says that you have to invoke the statute or the rule by name. I think it's enough if you simply make the relevant argument in enough of a form that the judge should sort of know the argument you're making. Am I
right,
wrong on
and they
that?
didn't do that. To say we have a well child check is not the same thing as we want a second opinion. It's not the same.
Right,
And
but
they probably wouldn't even need to use the term second opinion to bring it to the conscious level of the court. I assume what you would say is they at least need to say something like, we're not happy with the advice we're getting from that physician. And so we want to get the baby in and get input from another physician, and to that end, we have a well checkup appointment tomorrow. Now it should trigger the judge, oh, we're getting it a second opinion.
If
But
they-
you're saying that there was quite a bit less than that here.
There was quite a bit less than that, and even if they had said what you said, then the judge still could not say, well, then you get the child back, because the child was in a state of a deteriorating condition based on the 326, that's in Exhibit 1. So the
Well,
judge,
that's a ground to deny it, but that's not an issue of preservation. If there's a deteriorating condition, that doesn't mean they didn't preserve
but that's
it.
why I said if they had said it to the clarity that Judge Orm had said, but they
Well,
didn't.
the lawyer said, quote, my client already had an appointment with a doctor here in Provo to get a second opinion and to have somebody else be able to help and assess that issue.
Was that
So
the
that seemed-
shelter? Was that the shelter
Yeah,
hearing?
it's the shelter hearing on page 15.
Okay.
And what they're saying is, assess that issue, the issue's here.
Right.
I mean,
So if they had said, and for that reason, we disagree with changing custody, he didn't say that.
But they're
because-
there arguing against the suggestion that they should lose custody at the shelter hearing. So why? It doesn't seem like those two dots are that hard to connect. They're saying to the juvenile court, we want our baby back. And they're also saying to the juvenile court in the passage read by Judge Mortensen, we have, I'm going to mangle the words, we have an appointment with somebody
for a
Well,
second opinion.
for a second
Okay.
opinion. Those dots seem to be, if not touching, very, very close.
It didn't seem like it was touching to the judge, like the judge wasn't coming to the consciousness of the judge. And I
But
make
that's
it-
their point. I think their point is that the judge misunderstood the law, which is why
No,
the
because
dots aren't connected.
once they were clear with the judge that, later on, like in one of the other hearings, the judge says, well, of course you get a second opinion. Of course you do. We're going to make arrangements with the division. But I'm making a belt and suspenders argument. One, they didn't preserve it. And two, even if they did, the child was in a state of deteriorating condition. And also the parents' history of not following through and the parents' history of kidnapping, there was good reason for the court not to return custody based on that.
Was the court aware of that history and background at the shelter hearing?
I can't remember if at the shelter hearing they knew about the father's second name, but they did have a history of the parents' failure to follow through. So, and also of the
Well,
of the parents.
They did, because the father, they brought up the name at first hearing, which was basically just a continuance. And
Right.
they asked about the name at the end of the actual shelter hearing.
But
as
the
well.
court also heard some of the cat and mouse things
Correct,
that were going
correct,
on.
correct.
And so there was reason to say, okay, I'm gonna err this time on the side of protecting the child. You know, if you want a second opinion, it's gonna have to happen while the child is in division custody.
Can I ask you a question about that? What exactly is the relevance of the fact that the father has previously absconded with the children if the thing in front of the court is whether these particular medical decisions they're making right now are medically neglectful? Because I see a little bit of daylight, or at least potential daylight, between those two.
Well, that was a reason not to return custody at the shelter hearing, because if you did that, then you're trusting the dad to not abscond with the children. And based on the history and based on, they found that the family in a motel, they had given them phony addresses, phony phone numbers. So there were a lot of reasons not to really trust that the father would comply with court orders. So that's why I think it is relevant.
Okay.
And then as to the neglect finding, is the reasonable parent standard. And the most that the parents could come up with is the Wallstrom letter. And the Wallstrom letter pretty much supports what Dr. Merkley found on March 26th.
I don't know that that's the most they've come up with. They've also pointed to the fact that the American Academy of Pediatrics is very, very favorable towards breastfeeding. And so if you're a non-medical parent of a newborn and you're aware that the American Academy of Pediatrics favors breastfeeding and you're getting an opinion from a doctor, which in their mind seems to say the opposite, they at least think that they've got some reasonable basis for questioning that. Why is that wrong?
Because Dr. Wallstrom, as well as Dr. Merkley, both supported breastfeeding. But they said if the child's not getting enough, if the child is having problems with electrolytes and maintaining a weight, then it either has to do with a lack of production or the child not
But
being able to.
what if the parents just reasonably think that the first doctor is wrong?
Well, the parents could reasonably think that, and that's why you have the deteriorating condition, because you also have to have an objective standard. I mean, we can disagree with doctors, but that doesn't give you leave to do what you want, and that's why there's a mandatory reporting statute. So you have to. So there's an objective standard here too. So unless there's further questions, I'm going to thank you for your time.
Thank you. Mr. Peterson, we're now in uncharted ground. Let's see if this works.
All right, can you hear me?
I can hear you.
Cindy? Okay, very good.
All right,
May it please the court, John Peterson on behalf of the state of Utah. As we noted, what the parents are asking really is for a lot of armchair quarterbacking. After the fact, the child didn't die, so apparently it wasn't that serious. But for the judge on the ground, there are a lot of very concerning circumstances, starting with the court's initial decision to grant a warrant for removal based upon the parents' complete failure to heed reasonable medical advice, and the fact that the child was getting ready to go off the radar and they were in a hotel, and there's a very strong basis to believe that they were prepared to flee, as the father had done in a prior case involving a different child. And so the juvenile court reasonably granted a warrant, and the statute, Section 304, does allow for a child to get a second opinion for the child to remain in the parent's custody. The child was not in the parent's custody by the time of the shelter hearing. And the question at that point is simply whether or not the child could safely be returned. And given the fact that there was medical evidence that the child's condition has been deteriorating, the judge reasonably erred on the side of caution. Is it possible that the child could have been returned and not have been harmed? It's possible, but it's also very possible that the child continued not to get adequate food, and particularly not adequate liquids and dehydration. The child's condition could have deteriorated significantly. And the child's condition clearly was deteriorating. The child had been losing weight consistently since he was born. And there was compelling testimony from Doctors Merkley and Stroshin about things that could happen, bad things that could happen, brain damage, liver damage, things based upon, dehydration is a serious factor. And it's also worth noting, this is also not a case where like a week later, child was doing fine, and everybody said, okay, we're going to return the child to you. It was months. It was, I believe, 5 months before the judge even authorized a trial home placement, which really belies the idea that the parents were on board with providing proper care for their child.
Can I take you to a particular part of this? Let's skip past the shelter hearing and let's get to the question of whether there was clear and convincing evidence to support the adjudication of neglect. You with me so far?
Yes, I am.
Okay. If I've got it right, the statutory standard that's in play turns on whether it was a healthcare decision made by a parent unless the state proves by clear and convincing evidence that the decision was not reasonable and informed. And I take both sides' positions on this. On the one hand, you've pointed to Drs. Merkley and Wallstrom and so forth. But on the other hand, it's not like they've got nothing. They're, as I indicated in the previous question, they're pointing to the American Academy of Pediatrics. They're pointing to various other things. And it feels to me like there's at least some evidence on both sides. And just putting the card on the table, one of the things that I'm struggling with in this case is the standard that the state had to carry below, clear and convincing. And that's something of a hurdle for the state. And so I'm wondering if you can give me two things. One, give me everything you've got. What exactly was the basis for the neglect adjudication? It was what? The failure to add formula to the breastfeeding, or was there more? And then the second thing is the sort of broader question. What's your pitch for why that was clear and convincing evidence despite the evidence that the parents have? It was a long question. I apologize.
Okay, I'll start by that, the parents didn't actually provide, countervailing expert testimony. They provided a letter from Dr. Wallstrom, but it's really just a letter of sort of an out of sight expert reviewing things and saying, yeah, this is kind of what it looks like to me. The two doctors on the ground were Dr. Merkley, kind of got the ball, and Dr. Stroshin. And, the course of events, and the parents, suggested we just wanted to breastfeed. And, as Ms. Pierce noted, Dr. Merkley didn't have a problem. He didn't say, no, you have to do formula. Formula is the only way this child's going to live. But he wanted to reasonably know how much breast milk are you creating? Is this even going to be adequate? I need a baseline to determine that you're actually that what you want to do is reasonable. And
so it's the failure to agree to the breast milk testing. It's that plus the lack of formula.
Well, there are more than that. It's not just. There's also the failure to to come back. I need basically. He said also, we need follow-ups. We need to come back. I want to make sure this child's doing okay. And just their decision basically to go off the radar. We're not coming back. We're not going to the doctor. And it really looked like what they're getting ready to do is flee and do their own thing.
To state the obvious, if a child's healthy, parents can leave whenever they want, right?
Yes, but he wasn't healthy. He was distinctly non-healthy. And so to some extent, you are left a little bit. What happened? But there is the empirical evidence that once hospitalized, placed in foster care, where he was clearly given proper nutrition and water, he thrived and he had no further problems. There was no more issues whatsoever. Were simply in the before removal from the parent's care. I don't see that there's really much. Yes, did the American Academy of Pediatrics suggest that breastfeeding is healthy? Yes. Does anyone really disagree that breastfeeding is healthy? No. But are there mothers who are simply incapable of breastfeeding because they don't provide adequate nutrients or they don't provide adequate quantities of growth milk? Yes, there are. And the parents' refusal to even engage with doctors' reasonable requests suggests that they really weren't interested in a medical opinion. They were interested in doing what they personally believed to be right. While they do have a right to a certain degree of autonomy, Dr. Merkley saw this child precipitously declining and going in a direction where he could experience, irreversible damages. And he reasonably intervened.
But what do you do with their response? One of their responses to that is that there is some measure of decline that's normal within a child, and that we were somewhere in the ballpark of that. Why are they wrong about that?
There's some measure. Normal decline is pushing back really well. I really want to do this, I want to do that, but not just we're not going to show up. We're tired. No, we're not going to. Could you provide me? Could you measure breast milk? And also just it seems a general lack of communication. The father showing up sometimes. Oh, I don't have this. Oh, I can't talk to her. Oh, here, are we going to do this or not? No, we're just going to disappear. The record really suggests not a conscious medical decision, just an obstinate decision to do what they pleased.
So it may have been a medical decision, but it was unreasonable and uninformed. Is that? That's
Correct, Your Honor.
Okay.
That would.
I've got a mootness question, but I don't want to take us off that. Okay. Just to clarify the state's position on mootness, the guardian ad litem has come in, and as I understand the guardian ad litem's position, it's that both the shelter hearing issue and the neglect issue are moot. And the state came in and said, as I take your position, that the neglect hearing is not moot, but I don't see you responding on the shelter issue. In your view, is the shelter hearing issue moot or not?
Yeah, I mean, I think that I don't know, I guess I could go both ways. I mean, I think definitely on the evading review side of things, I mean, obviously the shelter hearing is not a final appealable order. And by the time you've gone through an adjudication, things have happened. I mean, there's very few shelter hearings being challenged. I mean, so I think, the idea that shelter hearings to evade review is a strong consideration. But there's also the fact that, what has been done is done, and you can't change those factors. And as I think it was Judge Mortensen noted, or was it Judge Orm, that you're not finding a lot of judges removing children, for failure to breastfeed. It's a fairly esoteric issue. So
you're not going to weigh in. You're not going to weigh in on that one definitively. Which is I suppose you're right. I just wanted, I wanted to get the state's take on that.
I think it could go. I mean, my response is I think it could go either way.
Okay, that's fair.
And on the side of neglect, I do feel that is not moot, just because at least this court's precedent is that once you have an adjudication of neglect, that provides a legal statutory basis for a termination of parental rights. So we come back here in 6 months, all of a sudden, let's say these parents do something else, there's an abuse allegation, we remove the children, we go through services, and we look towards termination of parental rights. We have a ground for termination of parental rights already established by this adjudication. So I don't think that you can say that there is, that is moot. At least that's to them.
Okay. Those are all the questions that I have, and I don't see any pending questions from either of the judges. Thank you very much, Mr. Peterson.
Thank you, Your Honor.
Rebuttal.
Your Honor, I'd just like to make 3 points briefly. 2 are factual. First, about the allegation that the 326 medical appointment with Dr. Merkley indicated a deteriorating condition. Deteriorating condition at that point was irrelevant. We agree that child was in fact losing weight, probably wasn't getting what child needed leading up to that 326 appointment. And that's when Dr. Merkley said, something needs to change. And unlike what the state and the guardian ad litem allege, parents did make changes. They began feeding child every 2 hours instead of the time period that they had had before. And that seems to have had an effect. As the court found, child did indeed gain weight between the 326 appointment and the April 1st appointment when the child was weighed by DCFS. The second factual issue, that the parents were engaging in surreptitious behavior and likely to kidnap child. 2 points. The parents told Dr. Merkley that they were planning on going out of town. They told Dr. Merkley on the phone that they couldn't attend the appointment because they were in Provo, not St. George. There was nothing that the parents were trying to hide. This was a pre-planned trip that didn't fit into their schedules.
You've got to concede, though. I mean, I understand they have the family down in St. George, but they have a residence in Provo, right?
Your
No?
Honor, the residence issue is unclear from the record. There were some allegations that parents perhaps didn't have a permanent address and that could have led to some of this moving
Well,
around.
I think, at least the judge's perception, because it was my perception reading the transcript, was that they did have a residence in Provo and that they're at a motel in Lehigh. And it's not necessarily the most nefarious thing ever, but it would make a judge raise an eyebrow, I would think.
Perhaps
because-
it could,
That's just not,
but families
No.
like to get away all the time, right? Especially where mother had other children and they had just had this baby. I mean, it's not unreasonable to believe that parents would want to just have one night away from everything else at home. And looking at the kidnapping issue, the fact that father had previously been adjudicated as having kidnapped these other 3 children, nothing in the record indicates that that had to do with an issue of medical neglect. In fact, it was a custody issue. He had the children for a weekend visit. And he had an absolute legal right to take his child wherever he wanted at this point.
Well, he did, though, hear a doctor say express concern and say, you need to bring the baby back in tomorrow for a weight check and some further testing. And the father says, no, we're not going to be doing that.
Yes, Your Honor, because he had had this standoff, for lack of a better word, with the doctor previously about the breastfeeding issue, and like Mother had expressed, felt like doctor wasn't hearing his concerns. So he had this previous engagement, he had planned to go out of town, and suddenly he has this disagreement with doctor, and it was clear that it was time to find another doctor, and it wasn't worth his time or effort to re-engage with doctor. However, he did respond to those doctor's concerns by telling Mother and, in fact, increasing the baby's feedings, which, to that point again, I'll point out that Dr. Stroschein's recommendation to the foster parents after finding that there was no medical necessity to admit the child or offer any medical aid was to tell foster parents feed the child every 2 to 4 hours. So Mother was following Dr. Stroschein's exact advice to foster parents on the more restrictive end of that advice.
And it all worked out, but I guess at no point did we satisfy the Dr. Merkley, I believe it was, the initial doctor's concern. Let's get her to pump so we make sure that we're not just going through a meaningless exercise here, be it every 4 hours or 2. Let's make sure that an adequate quantity of milk is being produced because I'm concerned about the weight loss. And your client says, yeah, I've been with other mothers, we've had other, I don't know about this breast pumping, we're not doing that.
Your Honor, I don't know exactly what went through parents' mind. Mother had other children that she had breastfed. I mean, I think Mother had some basis of knowledge of what her milk supply was going to be like, and there's no evidence presented by the state that would suggest that it was an unreasonable or uninformed decision for Mother to decide the best way to respond to the doctor's allegations the doctor's supposition that perhaps child could be dehydrated was to increase her feeding schedule to every 2 hours. I'm out of time, Your Honors. The last point I would like to make is that these two issues, that the adjudication and the shelter hearing, are independent issues. So if this court was to decide that the shelter hearing issue is moot, the parents can still, in fact, be successful on that second issue.
Great.
Thank you.
Thank you. Appreciate the arguments and briefing from all three sides in this case. It was helpful. We will issue a written decision as soon as we can, and with that, we'll be adjourned for the day. Thank you.